Welcome everyone to our update on recent changes to the employment law landscape in Australia. My name is Joel Hayden and I'm here with James True, who is the practice group leader of the employment law team at LegalVision. Before we get started, there's just a few initial matters. You will get a recording of this webinar after it completes. You can also submit questions throughout the presentation that we will get to towards the end, and we'll answer as many of them as we can. We would also really appreciate it if you provide some feedback at the end of the presentation. We always really like to hear what people think of these webinars. Following the presentation, you'll also be able to book in with our enterprise team by leaving your contact details in the survey. If you'd like to get in touch with us to see how we can help your business, that's the way to do that. So onto our agenda for today, and we do have a bit to get through. We'll be covering off some of the more significant recent changes to employment law in Australia. James will start us off by addressing the right to disconnect and contractor employee classification, and then I'll cover off changes to casual employment and the new costs regime for discrimination and harassment claims. So I'll hand over to James to get us started with the right to disconnect.
Thanks, Joel. So yes, look, many of you will have heard about the right to disconnect and know a little bit about it. Some important issues. First is actually about when it commences. If you're a business with 15 or more employees, then this right has already come into play from 26 August this year. And for small businesses, that's any business with fewer than 15 employees, there's still a year before this right commences. Now, the right to disconnect, it's not a world first here in Australia. We've seen similar rights in France and Germany previously. But let's have a look at this express wording, which we have up on the screen there. The employee can refuse to monitor, read, or respond to contact or attempted contact. Here's the important bit: unless the refusal is unreasonable. So as always, helpful drafting from the legislators there to make it as simple as possible, but this is what we've got. Some important things to consider in relation to this right. One, that contact that's being referred to there can also relate to third parties, so it extends to client contact. The most important thing to take away in relation to this right to disconnect, this is not a ban on contacting employees outside of hours. It has probably been misreported as being exactly that, but it's not. The law does not prohibit the contact. It just creates a right for employees to not monitor it, read it, or respond to it, other than when to do so would obviously be unreasonable. So let's take a look then at what is unreasonable. Context is critical. Considering all these factors put together is what's going to create an ultimate picture of what reasonable or unreasonable is. Looking at the reason for the contact, for example, if you have an employer who's just trying to send a note to someone to say, hey, look, tomorrow's start time or tomorrow's start location is going to be different to what we had planned, well, that's probably going to be a reasonable basis to do so. As opposed to if we're asking someone, to perform work that's not actually necessary. How the contact is made and the level of disruption, that's relatively self-explanatory, but it goes into similar types of matters. Phone calls are more disruptive than text messages. Again, depends on the demand we're placing on the employee. Compensation is probably a critical one. This for two reasons. One, generally, the law here is saying that, if you're well compensated, well, then it's more reasonable for you to do work outside of hours. But secondly, when it comes to compensation, those who are paid higher salaries are most likely going to have clauses in their employment contract, which require them to perform reasonable additional hours. So they're already contemplated doing work outside their ordinary hours, and they're already compensated for it. Employees' roles and responsibilities, again, you can probably look at this as the more senior you are, the more you might expect these types of, or the need really to perform work outside of hours as a sort of very general rule. It's just another factor that will be rolled into all of this. And then, of course, personal circumstances. So we can expect things like, those who have care of a child, or, other sort of carer type responsibilities outside of work, or whether there's a health condition that they're dealing with, all of those types of factors can be rolled into the consideration of unreasonable. Now, functionally then, if an employer is then trying to contact someone, that person wants to exert their right, taking into account all of those factors. The next question is, well, what happens in the case of disputes? For those of you familiar with the stop bullying jurisdiction in the Fair Work Commission, this is a very similar process. The first attempt at resolution in these right to disconnect cases will just be about try and resolve it between the employer and the employee. And ideally that's where it ends. Failing resolution there, that opens up a pathway for the employee to apply to the Fair Work Commission. And what they're asking the Fair Work Commission for is an order to prevent the conduct, so prevent the contact outside of hours. The critical thing to be aware of here, and this will probably drive the extent to which we see these types of orders being sought by employees in the Commission, is that there are no financial penalties for that initial contact. So an employee cannot run off to the Fair Work Commission and say, I've been contacted outside of hours and I want to be compensated. They won't be able to get that remedy. However, if the Commission has made an order, say that the employer doesn't contact the employee outside particular hours, they've got a very broad range of orders that they can make, and they can get quite particular with them. But if they've made an order and then the employer, say, breaches that order and continues to contact in contravention of that order, then yes, there can be penalties for that order, so for that breach of that order. So, as I said, this is probably something which will determine whether we see a lot of these types of cases rolling through the Commission. Of course, this isn't a new regime or a new avenue for employees to chase underpayment claims. If they're working outside of work and they haven't been paid for it, then this doesn't extinguish any of their rights to go and seek back payment. That will be an entirely separate type of issue, but very much a watch this space. We'll get more guidance on that question of reasonableness as the Fair Work Commission rules further. We might wrap up on this one just with some immediate next steps. So I have these down as next steps. They're all very much things you can think about doing. There is, in a sense, very many businesses could do absolutely nothing here, and that would be sufficient. This is the employee's right to exercise. So there is a world in which you could just wait and see if anyone exercises the right. There's no immediate penalty if they do. But for those wanting to be proactive, one thing to start with is the employment contracts. So you can think about whether you need to amend mainly the remuneration section in an employment contract. And you're really trying to do this just to put the employee on notice that, the remuneration, their hours of work, we may contemplate some contact outside those hours of work. We may want a clause in there that the employee agrees that that contact will be reasonable. And we might also want to make sure that our remuneration is expressed to cover any additional hours. Now, for salaried employees, you probably already have that clause in those contracts. But if not, certainly worth adding in. Again, that's probably more for an underpayment issue, but it helps you on a right to disconnect issue. With policies, I mean, we've got the consider if they're needed. And again, you need to think about whether having a policy on this is going to do more damage than good. And there's certainly a balance to strike. It'll be very context driven by reference to your business and the nature of your workforce. In some businesses, that there won't really be a need. And when you look at all of those unreasonable factors, it's unlikely anyone's going to be going around and exercising this right to disconnect. But you may like to provide some guidance on the right generally. Maybe, and I guess the path you're trying to tread here is you don't want to go and arm all of those employees with knowledge of a right they can go and exercise. And the balance there is, of course, making sure that you're appropriately explaining what the right is and the circumstances in which they can exercise it. But you may find the policies more helpful for managers so they can understand when they need to limit their requests of employees outside of hours. Having said that, there'll be some businesses here, you might operate a global business across multiple time zones, and this is going to be a huge issue. So a policy clarifying how the business is going to handle that and the expectations about how everyone moves forward, well, that may be really helpful and really necessary. The final one there is train the managers. So short of having a policy, if you are concerned that, this is going to create issues and you've got some overzealous managers who are maybe not too respectful of the time of the people that they are managing, well, then it's worth sitting them down for a training session, maybe not committing anything to writing in a policy for everyone, but just working through with your managers on those changes. So look, a lot to think about, but there's a big element of wait and see when it comes to this area. With that in mind, we'll just roll straight on through into contractors and employees. In order to kind of update you here on where the law is now, just take you on a very brief history lesson. This area has been continuously considered in the employment space. So when we look at what the law used to say, and this is really for the 20 plus years prior to now, we had a concept basically that if we were going to make an assessment of whether someone was a contractor or an employee, we would look at the actual nature of the relationship. We wouldn't really be too concerned with the contract, and the contract would say this person was an independent contractor. The law would look through that. And some of the seminal decisions there actually use the language that, if it looks like a duck, it quacks like a duck, well, it's a duck. And that was the approach from the courts. As part of that assessment, the courts would look at the relationship by reference to two key indicia, and that was mainly integration and control. So how much is this individual integrated into the business of the principal? Or can we say that they're really clearly sitting on the outside, running their own business and providing services from the outside in? Or are they really looking and feeling like they're part of the principal's business? Maybe they're wearing a uniform, they're sending emails with the same email address as the company, all of those types of things. The second aspect being control. Not so much how much does the principal control what work is done, but really how much do they control the manner in which the work is performed. So with an employment relationship, you have a lot of control, and employers will exercise control in relation to, yes, not only what the employee has to do, but how they're going to do it. Contrast to, say, with a genuine contractor, who you might tell them what to do, but that's more about, here's the project, here's the output we want from you, but you're the expert, you carry on a business doing this, so I'll leave you to do it. I won't control the way in which you're going to do it. So that was sort of a well-established test under the law and the consideration that everyone would give up until 2022. And we got some high court decisions. Some of you might be familiar with the JAMSEC decision, the personnel contracting decision in the High Court. And the High Court flipped all of this on its head and basically said, where the parties have got a written agreement, and that sets out their relationship, well, that is the appropriate place for us to go and look to make a determination as to what the relationship really is. So if you've got a contract and if it sets out rights and responsibilities which are consistent with independent contracting, well, you have an independent contractor. And if it sets out rights and obligations consistent with employment, you have an employment relationship. It was a very conservative decision and very employer-friendly. And what happened really after that was a lot of employers got very comfortable then calling people independent contractors and making sure they got the contract right, and that was sort of, let's call it a blissful 2-year period where this was all a little bit easier for everyone. And as I said, certainly an employer-friendly time of life. Enter federal government, says, no, we're not happy with that. That's far too conservative. So we're actually going to change the law on this. And what the law says now, and this is a legislated definition of what an employee is. And this really takes us back to our pre-2022 position, which is, if it looks like a duck and it quacks like a duck, it's a duck. So whether an individual is an employee is to be determined by ascertaining the real substance, practical reality, and true nature of the relationship between the individual and the person. So the contract still may have some relevance to all of that, but certainly not determinative like it was for those 2 years from 2022. We're back to a control and integration test. Now, that's a very quick rundown of where we're at and how we got there. But with that in mind, we might just take a quick look at some of the key steps then that you can take to address this. Number one, review your contracting arrangements. So given the law has seesawed here, you might have some contractors who are, pre-2022, post-2022, or new ones you're bringing on now. Important just to understand exactly where everyone is at in your business, and making sure now that we're not still relying on those comfortable 2022 decisions by putting contracts in place when people are really in substance going to be employees. So basically just go and assess your liability. There is a regime for opting out of this new definition. Contractors who are earning over $175,000 from the engagement with you are able to opt out. It remains to be seen whether that can be prorated or what will happen with that high income threshold, but at the moment they'd need to be earning that amount under the engagement. But if they do, you can basically go through a process where they opt out of that definition, and that resolves all your liability here. And the final point is just remembering super. Superannuation is under a different test when we look at a contractor's right to super. So there are going to be circumstances where someone is a genuine contractor, but they are still entitled to super. So exclude that really from reviewing your contracting arrangements and do a separate test for that. Now, that's a bit of a whirlwind on contractors and employees, but conscious of time, there's plenty to get through with Joel here in relation to the casuals. So I'm going to hand back to him to walk us through that. Thanks, Joel.
But as I was saying, there are 4 recent and very important changes to laws relating to casual employees. These changes all occurred as a result of the second tranche of the Closing Loopholes Bill and amended the Fair Work Act to include a new definition of casual employment, changes to casual conversion provisions, providing a new pathway for permanent employment for casual employees, restrictions on dismissing permanent employees to engage them as casuals under the general protections, and extended obligations in relation to the provision of the casual employment information statement to casual employees. Now, these laws represent a clear policy of prioritising the ability for workers to transition to permanent arrangements to provide greater stability and certainty for workers, while also protecting current permanent workers from the casualisation of their roles. So we'll run through what those changes are in a bit of detail, as well as provide some proactive steps that can be taken internally to ensure compliance moving forward. And first up on the slide currently is the new definition of casual employment that has been included in the Fair Work Act. And this provides that an employee is a casual where there is no firm advance commitment to continuing an indefinite work, and they are entitled to a casual loading or specific rate of pay for casual employees under a Fair Work instrument or employment contract. In assessing whether there is an absence of a firm advance commitment to continuing an indefinite work, the real substance, practical reality, and true nature of the employment relationship must be considered, as well as any understanding in relation to the engagement between the parties, including where this is outside of the employment contract. And that would be an understanding of ongoing, definite work. That's the type of situation that could result in that being relevant. Whether or not the employee can reject or accept work offered to them, the availability of future continuing work, whether permanent employees perform the same kind of work, and whether there is a regular pattern to the work being performed by the employee. And as with the changes to the definition of employment under the Fair Work Act, these additions are really meant to reflect an approach of assessing the true nature of the relationship rather than just the contractual terms agreed to by the employer and employee. Where a casual no longer fits within this definition, this will allow them to transition to permanent employment potentially, but it does not automatically result in this change. And so what it does is allow that employee to potentially go down this new pathway to permanent employment. So it's a good question to ask, what does that actually look like as well? Currently, casual conversion provisions under the Fair Work Act are in place that require an employer to make offers to casual employees to convert to permanent employment in certain circumstances. And that would normally be after 12 months where there's a regular pattern of work for the prior 6 months. But from 26 February 2025 for most employers, it's 26 August 2025 for small businesses, this process will change to the new employee choice pathway. Under this pathway, a casual employee will be able to make a request to transition to permanent employment where they've worked for at least 6 months or 12 months for a small business employer, and they believe they no longer meet the definition of a casual employee. An employer would then need to respond to this request within 21 days. And if it's accepted, the employee will obviously transition to permanent employment. If for some reason that request needs to be refused, there are only certain grounds on which an employer can do that. And that will be where the employee still meets the definition of a casual employee under that test we just addressed, where there are fair and reasonable operational grounds to refuse the request, or where acceptance of the request would result in non-compliance with a recruitment or selection process law. So where an employee disagrees with an employer's decision in relation to their status as a casual employee, they will be able to commence a dispute through the Fair Work Commission to have this arbitrated. And this change represents a shift to empowering employees themselves to trigger a conversion process and takes away the obligation for the employer to actively monitor and notify the individual in relation to their eligibility to convert. And this makes a lot of sense in our view, and it actually takes some of the burden off of employers in relation to addressing casual conversion obligations. Another change to the Fair Work Act is that the general protections provisions have been extended to protect permanent employees from the casualisation of their roles. And these new protections prohibit an employer from dismissing or threatening to dismiss a permanent employee to engage them as a casual employee to perform the same or substantially the same work, or to make false statements to an employee in order to persuade them to enter into a contract for casual employment where they will perform the same or substantially the same work. And like the rest of the general protections, both of these new protections are civil remedy provisions. And so where an employer contravenes them, penalties under the Fair Work Act can be ordered against the employer as well as knowingly involved parties, and that could be decision makers within the employer. These provisions are very similar to the sham contracting provisions under the Fair Work Act, and are clearly intended to preserve permanent employment for employees already in those roles. It's also important to note that other aspects of the new casual laws will form the basis of a workplace right under the general protections provisions, such as the right to request casual conversion and to dispute their status as a casual. And so it's vital that any employee is not victimised or disadvantaged because they exercise these rights, in addition to those new provisions that we have mentioned. Now, the final change to the Fair Work Act in relation to casual employees is that there are new obligations in relation to the Casual Employment Information Statement. So similar to the Fair Work Information Statement for all employees and the Fixed Term Information Statement for employees on fixed and max term contracts, the Fair Work Ombudsman is required to prepare a Casual Employment Information Statement for casual employees. The requirement to provide this statement to casual employees, the timing around that requirement has now changed. It was previously just on the commencement of employment. Now, for most employers, it will be necessary to provide this statement on commencement, and then again after 6 months, then a further time after 12 months, and then every 12-month period following this. For small business employers, i.e. those with 14 or fewer, this requirement will be to provide it on commencement and then once more after 12 months. And the purpose of this is to ensure that casual employees are aware of their rights in relation to potential pathways to permanent employment, as well as what they can do if there is a dispute about their status as a casual employee on an ongoing basis. And it does sound like a relatively basic document to have to provide to casual employees, but it's important to remember that if it's not provided, that will be a breach of the Fair Work Act, and there could be penalties relating to that. But given there has been quite a few changes relating to casual employees, it is important to ensure that internal processes align with these new laws. So to ensure compliance, we would recommend that all businesses take steps to gain an understanding of whether its casual employees are likely to fit within the new definition of casual employment. If there is some likelihood that casuals are working in ways more akin to permanent employees and are not captured by this definition, it is helpful to form a view in advance on whether conversion to permanent employment would be required to ensure the business is prepared should an employee approach them in relation to this. Internal processes should also be changed to reflect the new requirements. Once the new employee choice pathway kicks in, businesses will no longer need to proactively address casual conversion as they were previously required to. However, employers will need to ensure that the casual employment information statement is now being provided as frequently as it needs to be, which is a pretty significant change for processes. Finally, businesses should ensure that decision makers are trained and educated on the new general protections provisions to ensure that employees are not subject to victimisation for exercising their workplace rights in relation to the new casual laws. Similarly, make sure permanent employees' roles are not casualised in breach of the new general protections. And now, moving on from those changes to casual employment, a final update in the employment law space that we want to provide and that we think all employers should be aware of is a change to the cost regime for federal discrimination and harassment claims, with this including sexual harassment claims under the Australian Human Rights Commission Act. This change is the implementation of the final recommendation of the Respect at Work report that the Australian Human Rights Commission put out a few years ago now, and it institutes an approach to costs in discrimination and harassment cases that where an applicant is successful on one or more grounds, the presumption will be that the respondent, i.e. the usual role for an employer in those types of cases, will be responsible for paying the costs of the applicant. However, on the flip side, where a respondent successfully defends those types of proceedings, even in full, they will still have no recourse to pursue their costs against the applicant in most circumstances. And this new approach is meant to reduce the barriers to a person filing discrimination or harassment claims by removing the risk of a significant cost order should they be unsuccessful. It's a step further than the usual no-cost jurisdiction that applies in most industrial claims, which speaks very clearly to an intention to encourage people who believe they have been discriminated against or harassed to speak up. The implications here are pretty clear. Employers can expect to receive more claims. Individuals with good claims will be encouraged to pursue them, as the prospect of a cost order, if they are successful, provides further incentive, while even individuals with weaker claims will be more likely to also pursue these cases, as they won't have that threat of an ongoing cost order over their head. They'll be able to proceed as if it's no cost, essentially, even if the respondent doesn't have that same benefit. And where a claim is made, the risk will also naturally be higher for an employer now, given the potential cost implications on top of any successful claim made by the employee. So that does wrap up the update that we want to provide, and we will get to your questions very shortly. We're just going to cover off a couple of matters first, and that's that you may find it useful to download a summary of the 2024 key employment law changes, which you can do on that slide up now. You may also be interested in our upcoming event on building a safety first culture, which is on at 11 a.m. on 31 October. Just wanted to say as well that by becoming a LegalVision member, your business gets unlimited access to our full team of over 100 specialist lawyers for all your business as usual legal needs. It's like having another in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and review of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration and much more. We're a full service commercial firm. And we do offer a dedicated service for a lot of in-house teams and general counsel to manage their high volume business as usual legal tasks. And if that is something that interests you, please book in a call with our enterprise team by filling out the survey at the end of the presentation. So now to get to some of the questions that we have received, we might start off with a couple for James. what are your practical suggestions on how best to approach contracts for your contractors following these changes?
Yeah, so I mean, number one is really kind of a workforce review, understanding, well, what are our needs, how best are we trying to service them, and also making an understanding of what is our appetite for risk here. When we talk about going back to how the law was sort of pre-2022, it was quite common for businesses to say, all right, well, yes, we're going to engage this individual as a contractor. However, we're going to be paying them a lot of money. The arrangement is at their initiative. And maybe it's because they've got a family trust or some other, tax beneficial way of structuring their finances. And so they want to be sending invoices. Yes, we might have some exposure on whether they're actually an employee, but the risk is low in terms of this turning into a claim. That was a very common approach for businesses to take. And in a sense, we're back there in the same place. So practically, yes, you're going to need to go and do a review. And that starts with understanding how many employees have we got, how many contractors do we have we got clear delineation in terms of why we have contractors doing this area and employees doing this area, or have we got a very strong mix? And I think if you were to see you've got a strong mix of, lots of jobs that are being performed by employees, but also by contractors, that's probably your first red flag. So yeah, map the workforce is number one. But then actually go and make an assessment. So look at your contractors and get an understanding of how they work. You want to make that assessment as against, are they the integration and control issue? And so, I mean, that's certainly something we help a lot of clients with, to understand the liability there. But yeah, come to a view on liability and then come to a view on whether that's something you're actually concerned about. So yeah, as I said, practical first starting point, map your workforce and move from there. Start looking at the contractors after that point. And if you've got a huge number of them, simple way to maybe start doing it is looking at the ones who are doing the same job as other employees, or, leaving the ones who are extremely highly paid to the end. You could take any approach you like there, but something like that might be sensible.
And we've had a question, James, about, is there a best recent case about the treatment of employees compared to contractors, which is a good question.
Yeah, so in a sense, no recent best case. If you'd asked me before 26 August this year, I would have told you it was those high court decisions that I mentioned that were in place during 2022 to 2024, and that's the JAMSEC and personnel contracting decisions in the High Court. They were very much the authorities which told us everything we needed to know. We've only had the new legislated definition of employee since August 26 now, this year. And so yet to see any significant or instructive case on that. In a sense, the law is meant to be clear enough that that's where we go to. So yeah, right now, not so much looking for the big seminal case, rather that definition of employment in Section 15AA of the Fair Work Act. That's your place to go to now to make that assessment.
Okay, great. And I'll answer a couple after this last one for you, James, but how does this affect overseas contractors? How should we be looking at them compared to Australian contractors?
Yeah, super interesting question, and it can go into quite a complicated answer. Ordinarily, when you're looking at overseas contractors, the question will be, well, are they covered by the Fair Work Act? Now, historically, we would have answered that by saying the Fair Work Act has a carve out in that it won't apply to an employee who has been engaged outside of Australia to perform work outside of Australia. So if we had someone overseas who'd never set foot in Australia, we could have been fairly confident that, okay, well, the Fair Work Act is not going to apply to them. And it's the Fair Work Act which has all the sort of sham contracting provisions. It has the definition of employee. So if the Act doesn't cover them, we could treat that overseas worker differently and not worry about that liability under the Fair Work Act. However, End of last year, we've had a decision in the Fair Work Commission. Now, it's a single member decision, which means it's not exactly the authority and it doesn't have to bind everyone, but for the moment it's there and we need to follow it. It basically says that when you're looking at that question of whether someone has been engaged outside of Australia, it goes into a very complicated analysis of electronic transactions legislation. If you've sent an email with a contract in it from Australia to an individual based overseas, the place then that employer receives the signed contract and the acceptance of the offer amounts to the place that the contract is made. And so what that means is that even if you had a worker who was never in Australia, had always been overseas, never set foot in Australia, and they were contracted by an entity in Australia that was based in Australia, then that person could be engaged in Australia. It's a very counterintuitive decision, but nonetheless, it's a decision from the Fair Work Commission that we've got to follow for now until someone wants to start some very complicated proceedings in a test case and try and overturn it. But that really changes things for businesses. And so in a sense, number one, for your overseas contractors, you really need to sort of do a deep dive on how they were engaged and understand, can we carve them out from application of the Fair Work Act? And the short answer there is that's going to be much harder than it used to be, thanks to this decision at the end of last year. But number two, then still you want to go and make an assessment of the relationship. So if you assume that the Fair Work Act does apply to that relationship just to be safe, then you would treat them the same then as your Australian-based employees. There may be some natural differences in the sense that, when you look at integration and control, someone based overseas is maybe less integrated and you maybe exert less control over them. But, with an online workforce, it doesn't really matter. So that, those types of things won't necessarily have an impact. So certainly worth, exploring the application of law question as a starting point, and that can resolve all your issues. But if it doesn't, then throw them in the pot with everyone else. You've got the same legal liability there. You may have less practical liability in the sense that if that overseas worker tried to claim they were an employee, they might have to front up to an Australian commission or tribunal or court to run their case, and they're less likely to do it than someone who's local, and they're probably less likely to have the Fair Work Ombudsman help them do that. But from a strict legal sense, it'll be the same position, assuming that law applies.
Exactly. So quite a complicated area. There's potential application, even though they are overseas, and there's a commission decision that's not particularly helpful there by the sounds of it. Now we've got one about casual employees, and under the Hospitality Award, are we required to proactively offer casual conversion to employees? So the obligations under the modern awards will reflect what the obligation is under the Fair Work Act. And so currently, yes, there is a need to actively monitor casual employees and make those offers under the old laws, we'll call them, which is after 12 months of employment, if they have 6 months of regular and systematic work. But that will change to what we discussed a little bit earlier, in that now will be the employee's choice to approach an employer where they believe that they should be transitioning to permanent employment. And there's a related question that asks, is there a minimum number of hours they would need to work to be considered for that employee choice pathway? It's not so much about the number of hours. And of course, a very limited number of hours a week will maybe reflect casual employment more than permanent employment. But of course, if someone's got a regular pattern of working, say, 10 hours a week, even if it's relatively limited, if it was on an ongoing basis and the other indicia are looking like a permanent employee, i.e. carved out of the casual definition, then it's still quite possible that they could transition to permanent employment. It would just be to part-time permanent employment as opposed to full-time permanent. So lower hours may be reflective of casual employment, but it's not going to be determinative, and there'll still be an obligation to look across all of the circumstances for that employee. We've got a question now, James, in relation to the right to disconnect, and does this mean that for employees with reasonable overtime wording in their contracts, then it's never unreasonable to contact them out of hours, or is it just one factor?
Yeah, it's just one factor. That will help, certainly, with the idea that it's already dealt with in a contract. And I suppose one of the big questions, when you look at the other factors to consider, including remuneration there'll probably be a distinction here between, you know, contacting people outside of hours versus actually having people perform overtime. So if you're asking someone to stay back or come back and perform more work, and they're going to be compensated for that extra work that they're performing, and presumably at some kind of overtime rate, that's going to be less of a right to disconnect issue, in that that's more of a reasonable overtime issue, and awards and the Fair Work Act will deal with when is it reasonable to require additional overtime. So it becomes a separate issue. I suppose an employee could then go and try and agitate that issue as a right to disconnect matter, but they'd be better off dealing with it as a reasonable overtime issue. So yeah, in short, yes, it'll be a factor. It won't give you an unfettered right to always be contacting them, but important to look at requesting overtime, and then otherwise contacting, you know, employees outside of their ordinary hours, where they may exercise that right to disconnect, as sort of two separate things.
And in the same vein, in relation to the right to disconnect, how effective are disclaimers in emails and messages, you know, that say that, you know, this message is being sent now as the timing suits me. I don't expect that you will read or respond or action it. What's the relevance of those types of disclaimers?
They're really good as long as they're actually followed and enforced. So what we have seen is people include that, but they actually expect a response. So there's a culture of expecting a response, notwithstanding that that's said. So if it's included there, and yes, you know, we also are, as part of the right to disconnect, we're also having to acknowledge that other people want to work flexibly, and they can be a really sensible way to do it. So as long as, and maybe this is where a policy comes into play and sets the expectation for everyone and says, look, some of you want to work flexibly, some of you want to work in accordance with your ordinary hours, and therefore, you know, if you're working flexibly, you've got to use that, and you're not allowed to expect. You've got to use the signature or the disclaimer, and we're basically going to rely on those and they need to be taken as though they're communicated seriously. So yes, very, very effective and a good way ultimately of saying, I'm not asking you to monitor this. No one is trying to get in touch with you here outside of hours. We're just having something that's waiting for you when you sign back on. So yes, they are helpful. They just can't be sort of a sham, put it that way.
Yeah, absolutely. We've got a question about the timing of those new obligations around the casual employment information statement and when that commences. That obligation is live now, and the actual need and the timing based on the 6 months, 12 months commencement, etc. It's time from the commencement of employment, not from the commencement of the obligation. So just keep that in mind. We're looking at employment. That obligation is now live. And we've also had a query about whether having an opt-out notice template is something a business can have prepared. Absolutely, that would be a great query to address when you submit your survey answers at the end, and that's something we could absolutely have a chat about with you. Okay, great. Well, that wraps up all the time that we have today. Thank you everyone for coming. And again, fill out that survey. And if you want to get in touch with us, just leave your details and that at the end of the presentation. And otherwise, thank you very much for joining us this morning. We hope it's been helpful.